Next, we have Senate Bill 1087. Senator Okonowitz, welcome to our committee. Please come forward, state your name for the record, and tell us about your bill.
Thank you, Mr. Chairman. Doug Okonowitz. I'm a senator from Legislative District 3. I live in Hayden, Idaho. Today we've got for your consideration Senate Bill 1087, which is often said axiom or often used axiom. This is actually a pretty simple bill. Truly, it is this time. The notion or the idea was brought to me by Detective Neil Urig. He's behind me here to my right, from the Post Falls Police Department. So this is really his baby. I'm just helping him usher it through if the committee agrees with us. So the bill is also supported by the Fraternal Order of Police. We've consulted the Idaho Prosecutors Association to make sure that they were comfortable with all of the language, and we work closely with the Attorney General's office on what we have here. In short, what this legislation is it will require that any individual convicted or who pleads guilty to any crimes against children under sections 18-1507 through 18-1509A, it makes the property that or the assets that they may have employed or garnered as a result of a sale of some kind or other forfeit in the same way that our drug laws do. The best example that I got when I spoke with Detective Urig way back when, in last fall, I believe, was right now police departments are forced to store computers, for example, that were used in the commission of crimes against children. And then once the convicted person is released or served their sentence, then they have to wipe those computers and return them to the person who used them for that crime. So I don't like that. I hope most of you don't like that. I think not only is it a drain on taxpayer dollars and labor to maintain these items that were employed to do horrible things, we then have to wipe them and then give them back to somebody who perhaps would be tempted to reinitiate in the practice that they were previously convicted of. Detective Urig has signed up to testify, I believe, so if not, I'd appreciate the committee taking time to hear from him. The bill is as simple as that, but to be clear, there's a definition of property that's subject to the criminal forfeiture, and it's not limited, but includes vehicles, real property, computer files, computer hardware, software, electronic data employed in any manner or part in the commission of a violation of those sections that deal with crimes against children. The rest of that language is essentially taken from the asset forfeiture section of Idaho Code that deals with drug law. It obviously has to be massaged here and there in order to fit, but again, we worked with the AG's office on that, as well as Detective Urig's sources. So that is it in a nutshell, and I'd be happy to answer any questions.
Thank you, Senator. Any questions for Senator Okonowitz? Senator Wintrow.
Thank you, Mr. Chair and Senator Okonowitz. Thank you for bringing this bill. Could you, when you referenced the civil asset forfeiture related to drug violations, could you maybe show us in the bill what's really similar about yours as well as that one? And the only reason I ask is I know we've had other bills in our body before that we've kind of wrestled with in this area, and so I'm just kind of curious about the symmetry of those.
Senator Okonowitz.
Mr. Chairman, Senator Wintrow, I can read them to you. Obviously that's Title 37, Chapter 2801 for the property subject to criminal forfeiture under drugs. The truth of the matter is I left the gritty details to the experts, meaning the Attorney General's office and our drafting attorneys. So I'm not, the way it was explained to me is that it was built on that. I think you'll see a lot of similar language, but obviously a few things have to be changed here and there, I'm assuming, in order to fit the subject matter at hand today.
Follow-up, Senator, go ahead.
Thank you, Mr. Chair and Senator O'Connor. Maybe there's somebody that's going to be testifying with you today that could just help showing without reading it, of course, but kind of saying, oh, yes, here are the sections that are very similar to the drug piece and those kind of things. That could just be helpful to me.
Thank you, Senator. Any other questions for Senator O'Connor? Senator Foreman.
Thank you, Mr. Chairman and Senator O'Connor. I understand the intent behind this, and having worked a number of these cases, well, they weren't my favorite type of cases to work. But the part about this that just troubles me is the asset forfeiture aspect of it. I've heard from numerous constituents that say we ought to be able to separate the criminal and the crime from personal property. And it's a slippery slope, I think, when the state starts to take private property and engage in asset forfeiture. I read the bill a couple of times, and one of the things that troubles me is I could be a co-owner, innocent as the day is long, didn't even know that the crime was being committed. And I, in essence, have to prove my innocence in order to retain my property. And that's kind of backwards from the way we normally do things in America. Again, I understand the intent, but if you could just speak to that. I don't have a question per se, but that's really bothering me.
Senator O'Connor.
Mr. Chairman, Senator Foreman, I'm happy to talk to that. I struggle with asset forfeiture to some degree as well, and I guess the way I reconciled this issue in my head is that with extremely heinous crimes, or the most heinous crimes in our state, we have the death penalty. I probably could be convinced that that might fit this area as well, in which case you lose your assets anyway. It's a bit more of a reach than committing murder. So this seemed to me to be a reasonable approach, not far off from losing your assets if you are convicted of a crime such that you're subject to the death penalty. So I think you asked my thought process, and that was part of it. So I hope that helps.
Thank you. Any other questions for Senator O'Connor? Okay, I don't see any. Senator, thank you.
Thank you.
We'll move on and then give you a chance to close. Okay, next I have Neil Uhrig. Uhrig. Okay. Uhrig. Mr. Uhrig, welcome to the committee. Please state your name for the record, and then if you could keep your testimony to 3 minutes, and we may have some questions for you.
Yes, sir. Chairman Lakey and members of the committee, thank you for allowing me to testify today in support of Senate Bill 1087. For the record, my name is Neil Uhrig, and I'm from Post Falls, Idaho. I'm a detective sergeant with the Post Falls Police Department, and I speak to you today both on behalf of my police department and also the Fraternal Order of Police. I drafted this bill with Senator O'Connor to resolve a problem I've encountered in my duties as a police officer. I'm a member of the Internet Crimes Against Children Task Force, and I'm also a task force officer with the United States Secret Service. I operate the only full-service digital forensics lab in North Idaho, and a vast majority of my work involves child pornography and child exploitation. Under the current state of the law, when a child pornography offender is prosecuted, the digital devices they use to commit the crime are taken as evidence, but must be forensically wiped and returned to them at the conclusion of their sentence. Morally, I think this is bad public policy. The government should not be in the business of returning the tools used by child pornographers to commit their heinous crimes. Additionally, this adds to an already heavy case backlog, which takes time to wipe all these devices. Bill 1087 provides a mechanism for forfeiture of these devices, making it so we don't have to give computers back to child molesters. A lot of research and consultation has gone into this bill. It's been vetted by the Attorney General's office, various prosecutors throughout the state, members of ICAC, and members of Project Safe Childhood, which is through the U.S. Attorney's Office. The language used in this bill has been mirrored from the Controlled Substances Criminal Forfeiture Statute, which I think Senator Winthrow, is it Winthrow? I apologize. There are two, I want to address your comment or question in just a moment, but it is directly from there, from the criminal side, and there's a variation. This was done intentionally, and that was because law enforcement, prosecutors, and courts are already familiar with this process. This is much different than civil asset forfeiture, which has been considered controversial for some time. In civil asset forfeiture, property can be taken based on a preponderance of evidence. Bill 1087 uses the criminal forfeiture process. The person has to be convicted. If an offender is found not guilty, they get their property back. In my opinion, there is nothing controversial about forfeiting property used by convicted child pornographers and child molesters. Under this bill, digital devices containing child pornography will be destroyed after all court proceedings are concluded. Other involved property can be used by prosecutors and law enforcement for official uses, thereby assisting in future child exploitation investigations. This bill contains language that safeguards the rights of third-party owners. I feel this is important because sometimes offenders own property with their spouse or other innocent parties. This language provides a way for them to be heard in court and to recover property or the value of the property. Criminal forfeiture of child pornography evidence is well established across the nation. It is used in the federal system as well as Washington State, Oregon, California, Ohio, Nebraska, and Georgia. It's my opinion that Senate Bill 1087 is good public policy that will help law enforcement. The bill is built on solid legal analysis and is already used across America. There are very few crimes that are worse than child pornography. Simply put, child pornographers should have to forfeit the tools of their trade upon sentencing. Thank you for your time today, and I stand for questions.
Thank you, Mr. Yurg. Questions, Senator Winthrop.
Thank you, Mr. Chair, and Mr. Yurk. I really appreciate the time that you're taking here, because I think this is a very serious issue, and I think we can all agree on that. What I am questioning is, and maybe you can ease my mind.
Yes.
I totally get for like child pornography and so forth, using computers, taking those, and that's gone. That's a tool of the crime. But I'm wondering about, it says including but not limited to vehicles, real property, and then it has computer files, computer hardware, software, electronic data. Like, I feel really comfortable with the computer files, the hardware, the software, the electronic data, but vehicles and real property seems a little broad. And the reason I say that is, what if somebody's married to somebody who commits one of these crimes and that's their car, and you take the car, and then the victim or the partner of the other person then doesn't have a car or something like that. You see what I'm saying? So that's why I need a little clarification about that.
Chairman
Mr.
Lake,
Yurg.
Chairman Leahy and Senator Winthrop, thank you for your question. The way we wrote this, we did take it from the drug forfeiture laws in the criminal side, and it specifically has a safety valve built into that. The judge has to make a finding that the property was used in the crime. And so when you look at child pornography offenses, most of the time, this issue of houses and cars are not going to come to play. We just did a big bust last month in Post Falls, and it was done in a trailer. He made child pornography in the trailer. His spouse lives there, but the trailer was not a central component of the crime, so it doesn't include that. But there are times that child pornographers will build studios in their houses, and so they basically use their home to produce child pornography, and that should be taken with their sentencing. Regarding cars, that would only be in a situation where they're using it to transport victims or transport child pornography if they're selling it. So there is safety valve built in for that specific issue. I hear you though. Absolutely. We don't want to take stuff from a spouse that doesn't know. We definitely don't want to see that, but I think that there are safeguards built in, and I trust our judges on this issue as well. When they look at this, that they're going to be able to make solid decisions before taking property from an innocent third party.
Follow up, Senator. Go ahead.
Thank you, Mr. Chair and Mr. Yurg. Yes. Can you point to that in the bill that indicates what you just said, that it has to be linked with the crime? And then also, I'm assuming then that 18-1507, I think I looked those up earlier, 18-1507, 09A, those are all child enticement, or those are all referencing child crimes, right?
Correct. So all 4 of those deal either with, oh, I'm sorry.
Okay, Mr. Yurg, go ahead.
Chairman, I apologize. Senator, those codes specifically are our sexual exploitation of a minor child code, and they're also our child enticement codes. And so these are, not every child molestation code is going to come here. It's when there's actual production, possession of child pornography. Now, regarding that part in the bill, I'm going to have to kind of dig through this to get you.
First page of the bill, Senator.
Okay, thank you, Mr. Chair.
Lines 21 to 25. Mr. Yurk, have I missed anything else?
I'm just trying to make sure. I know that there's more. It might be worthwhile if I can I gather that for you later and get you that answer? I guess you guys need to vote today. Because I know it's in here. I just got to dig through, and I don't want you to sit here and stare at me. So,
Mr. Chair.
Senator Windrow.
And Mr. Chair, if you can, I just want, you see where my question is going. I just want to be sure that what the bill says, because I'm not an attorney, and so that's what I appreciate your showing me on that page 1. But to make sure that only the property that was used in the crime being convicted would be taken.
Well, Mr. Yurg's looking, the first section there in 1507B, it says any person who enters a plea of guilty or is convicted of a felony violation of those sections, no matter the form, shall forfeit to the state of Idaho, and then it describes the property.
Mr. Chairman, I did find the section. I did it faster than I thought, Senator. So if you turn to page 4 of the bill, line 44, this is subsection 9, and it says, in issuing any order under the provisions of this section, the court shall make a determination that the property or portion thereof in the case of real property was actually used in the violation. The property forfeited shall not be unfairly disproportionate to the property actually used in the violation of the provisions of this chapter. So we wouldn't take a car unless they used it in the commission of the crime. But there can be a situation where I've had child pornographers where they're picking up their victims in a car. He doesn't need to get his car back. But I appreciate the question. I hope that answers it for you.
Senator Windrow, go ahead.
Thank you, Mr. Chair and Mr. Yurg. So then it sounds like, too, that through the course of the case and what evidence is produced, and then when the conviction comes, the judge has the discretion of determining which property may be tied or not, as well as if, let's say my other example came forward that, that's the only car we have and I'm the spouse and I didn't know he was doing this or whatever. Now I'm without a car. Would that still be within the judge's discretion if somebody were pleading to the fact that, hey, please don't take that car because I own it too?
Mr. Yurg.
Chairman, Senator, yes, that would be something that's within the judge's discretion to make that call.
Other questions? Senator Ricks?
You guessed I was going to push
I
my
saw
button.
you reaching
up.
for your mic, yes.
Thank you, Mr. Chairman, Mr. Yurg. So can you kind of walk me through an example of how this would work on a hypothetical and the timelines and how would that work?
Mr. Yurg.
Thank you, Chairman. Thank you, Senator Ricks. Yes, I can certainly do that. So I'm going to use a case that I just did last month. This is a child pornographer where he was using his grandchildren to make child pornography. In that case, I seized all of his electronic devices. I did it under the federal system just because of certain parameters with that case. But if I was to do this in the state side, here's how this would work. I would have to issue an inventory. And then once an indictment or an information is handed down, I have 14 days to start the process, and that's the prosecutor is going to issue a notice saying that we're going to attempt to forfeit property. An investigation then will have to occur. Typically, that's working with the prosecutors and law enforcement to determine, are there third-party owners that could potentially claim ownership? Honestly, most cases, when we're talking about computers, child pornography offenders do not share their devices with their spouses because that's how they get caught. So very rarely do we have cases where we actually have to worry about third-party owners. But if we find that, we have to give them certified notice. And then there will be a hearing set, and then they can come and explain to the judge, here's the situation. And then at the end of it, once the person is convicted, the judge then makes a determination what property gets seized and held onto. So I hope that makes sense, Senator.
Senator Ricks?
Yeah, I think so. So what happens in the scenario, and maybe it's not, I kind of looked through the provisions here, but what happens down the road if an individual is exonerated or the charges were dropped? Is there any recover or reimbursement?
Mr. Uhrig?
Thank you, Mr. Chairman. Senator Ricks. Honestly, that was not something that I thought of, and that's a pretty good question. And I don't know how that happens specifically when we talk about the drug code. I used the criminal asset forfeiture for controlled substances as a guide for this, and I don't know if there's already a process built into that. I would assume that if someone is exonerated, there would probably be a claim that would need to be filed, and they would need to be made whole again. That would be my assumption, but I don't know honestly how that would work.
Okay, thank you.
Thank you, Senator. Okay, Senator Ruckty? Okay, all right. I don't see any other questions. Mr. Uhrig, thank you.
Thank you.
Appreciate you coming today. I know it's a drive. Or a flight, I guess, maybe. It's a long drive. So I don't have anyone else signed in to testify. Is there anyone else that would like to testify in Senate Bill 1087? Okay, I don't see any. Senator Okonowitz, we'll give you an opportunity to close.
Thank you, Mr. Chairman, committee. While I was sitting there listening to that, I was scanning the bill, and I think I've got a little bit more color on how a spouse or something, if they get caught up, and basically starts at the bottom of page 2 on line 45, goes through page 3 and most of page 4 on how it's all dealt with. So there are pretty exhaustive measures in place for people to make a claim that they were an innocent party, that they have an ownership interest, and the court, I guess, is instructed to take that into consideration when deciding whether or not to seize the property. And then they go into such detail as even how to distribute if it's sort of if it's worth less. Anyway, there's some valuation issues as well. But the only exception is that the provisions there don't apply to the electronic or computer hardware, which is what we're most focused on. That stuff doesn't get split back with an innocent party. So, but yeah, so there are provisions, pretty exhaustive provisions on how someone who has a right has to be, they've got to be given notice, they've got time to respond, make their claim that they had no idea that those things are going on, but they're a part owner. They've got to establish that ownership right, and then they have the ability to acquire that property, as I read it.
Thank you, Senator. Any questions for Senator Okonowitz? Senator Wintrow, go ahead.
Thank you, Mr. Chair. I'm sorry I'm asking so many questions, but it is a lengthy bill, and so I appreciate your patience. So I think that's what you're talking about there on page 2 that goes into page 3. These are all the processes by which somebody could file a claim to get property that's been co-owned, right? And it goes from 2 to 3. It talks about the hearing. I mean, that pretty much encompasses all of page 4 and 5, right?
Senator Okonowitz.
Mr. Chairman, Senator Wintrow, all I got to is the bottom of page 4. I didn't have much more time to read, but I know there's exhaustive language on how to deal with that. I stopped at that section where it said it doesn't apply to the computers and electronic hardware.
Okay, thank you, Mr. Chair.
Thank you, Senator. Any other questions? All right, I don't see any. Senator Okonowitz, thank you.
Thank you.
Appreciate you being here with us today. All right, Senators, we have Senate Bill 1087 before us. I'd open the floor for discussion or a motion.
Mr. Chairman,
Senator Anton.
I move we send Senate Bill 1087 to the floor with the due pass recommendation.
I have a motion from Senator Anton to send 1087 to the floor with a due pass and a second from Senator Lee. Discussion on the motion. Senator Foreman.
Thank you, Mr. Chairman. Just to talk about the motion a bit here. I heard it stated that we don't want to turn the tools used in the crime back over to the criminal because he or she might commit a crime in the future using the same tools. I can understand the logic there. But a person can be convicted for a crime committed, but not for a crime he or she might commit in the future. I think we'd be better to return the property and keep it separate from the crime so as not to create a burden on innocent people. And unless someone is charged with a crime, they should not have to file a claim to get back their lawfully owned property. So I'll be voting no on the motion. Thank you.
Thank you, Senator. Senator Ruckte.
Thank you, Mr. Chairman. So I've always been pretty critical of these civil forfeiture processes, statutes. I've got a law partner who was on Law Review because he's a lot smarter than I was when I was in law school, and he actually did an article on these civil forfeiture cases. So I've always just kind of paid attention to them, been interested in them. They've been criticized throughout the United States. These are usually civil forfeiture cases that deal with, when you find drugs, you have a drug case, and then it allows law enforcement to confiscate the vehicle that the drugs were in, and a variety of other things, kind of like what we've talked about here. I think this is by far just, the bad apple, but sometimes law enforcement have been accused of realizing that's somewhat of a cash cow for them because they get to keep the property or sell it and use the proceeds to help with budgets. And I'm not suggesting that happens very frequently, but that has been a problem in various parts of the United States. And you can kind of see that when you realize, oh, okay, we can use this to help us. I had one case, I don't do criminal law, but this was a civil case, a family from Boise who were from Pocatello and they still owned property there, and they wanted to fix up one of their properties. And they knew a contractor over here in Boise, and so they gave him money, $6,000 or $7,000, as I recall. It was, a chunk of change. And the idea was he didn't have a credit card. He was a good contractor, but didn't have access to a credit card, so they didn't have other ways of solving that problem. And he needed to buy stuff when he got to Pocatello at Home Depot and a variety of other things. So they gave him the money in cash, and he took it with him. He didn't abscond with the money, but on Friday night, he went down to Lava Hot Springs. And if you've ever been down to Lava Hot Springs on a Friday night, things get a little wild down there, and they got a little wild this night. All I know is there was girls and drugs involved, and at some point a police officer. So they confiscated the money. And my clients, the family from Boise, had to sue the money. That's how you get the asset back. So it was literally family name versus $7,000. And I went in and represented them. We got the money back. Now, there were a row of police officers out on the bench outside who were just convinced this was all about drugs. All I can tell you is, we showed the judge, and I can't remember, I think it was just a hearing with the judge, that it was their money, but they had to pay somebody to go get it. I mean, so that example, even though it's just one, it does demonstrate the challenges we have because the asset was owned or at least claimed by somebody else. It got caught up in this bad behavior that my clients had nothing to do with, but yet because of this statute, the civil forfeiture and the drug cases, they had to go hire an attorney and go get their asset back. So I'm just not a fan of going after people's property. I get it can be used in a crime, and that bothers me, but we do have criminal statutes that take care of that and allow juries to assess, punishment. And I think I just get really nervous about going beyond that. So I'll oppose the motion.
Thank you, Senator. Senator Ricks.
Yes, thank you, Mr. Chairman. There's parts of this I really like and parts that I don't. So I'm a little unsure how I'm going to vote here. I may vote against it, but with computers, and I have had quite a bit of experience with various computer systems over the years, but I I do think it's pretty easy to pop out a hard drive or run a bleach bit or a process that wipes those out, rather than having to destroy the whole computer system. And that concerns me. And also the question I had about, is there a way to recover or reimburse if a person is exonerated or the charges dropped later on, and then the evidence or these computer equipment's already destroyed. So that does concern me a bit. So I may be a no on this. Thank you.
Thank you, Senator. Just making my way down. Just one comment before I take others. Do keep in mind that there is a difference between civil and criminal forfeiture. This one requires a conviction, where the civil forfeiture does not. Senator Lee.
Thank you, Mr. Chairman. That was going to be my point, that this is a actual conviction, and these are difficult crimes to convict because we are talking about crimes against children. And I wonder if a different weapon other than a camera or a hard drive were used in the commission of a crime, would we hand that weapon back to someone when they were done with their sentence? And in my mind, that's exactly what we're talking about. I'm less concerned about the burden. I'm sympathetic to the burden of storing this property, but I'm also really wanting to send a message that the tools that you use to convict or to commit the most heinous crimes against the most vulnerable, we are not going to preserve that equipment and hand that back to you. I do trust that our judges, as our good Senator Recti demonstrated, I think in cases where even indigent individuals could come to our courts and say, this is my home, this is my car, I think our judges would be sympathetic, and I think the statute allows for that. But I just feel very strongly about this as a policy.
Thank you, Senator Lee. Senator Hart.
Thank you, Mr. Chairman. I sympathize with Senator Retke about the asset forfeiture laws, and I think we need to be real careful. So I think I'm a no vote on the motion, but if we had more time to look at this bill, we could hold this until Monday, I might be a yes vote. And so my question to the chairman is, transmittal date is Monday from one side of the building to the other. Do you have an update on that? And if I were to make a substitute motion to hold this till Monday, is that going to kill the bill for the session?
Senator Hart, that's a deadline, but it's also a bit of a guideline. I can't say that that would slow it down over here. I can't exactly comment on the other side. I know they kind of try to stick to deadlines, but I don't know that that's a hard deadline.
Okay.
I don't know if those in leadership have any additional comments there, but that's my understanding.
Okay, thanks.
Senator Winthrop.
Thank you, Mr. Chair. And I appreciate that distinction between criminal and civil. That really does help. And I do agree that if somebody is using the camera, the computer, et cetera, for enticing of children or pornography and those kind of things, that asset is forfeited because that was in the commission. My only fuzzy part really is many times the actual victims of some of these crimes are family members. And so that's why I was asking all those questions about what real property means and the vehicles and those kinds of things, because we don't want to harm the people who are being victimized, especially if they're connected with the person that's been convicted. But what I'm hearing, I think, from the chair is confidence that judges have discretion with those family members when it comes to those convictions. So, I mean, that's really just all I'm wrestling with, is to make sure we're not harming any victims unintentionally in the process. So that, again, I just want to be really clear about that.
Thank you, Senator. I'll just make a couple of comments. I think I'm kind of in line with the comments from Senator Lee. If this was a murder case and the firearm that they used in the murder, I think that's forfeit. It does require the criminal conviction. I think we have a tried process in these criminal forfeitures that works, and I think I have confidence in that process. I haven't heard that it hasn't worked, so to speak. So I'm confident in the process that's laid out in here, and I'll be supporting the motion. Any other discussion? All right, we have a motion to send Senate Bill 1087 to the floor with a due pass. All in favor of the motion indicate by saying aye. Aye. Any opposed? Nay. Okay, I think motion carries. Those in opposition, would you like to be recorded? Okay, so Senator Hart, Senator Foreman, Senator Ruckde, and Senator Wintrow. Senator Ricks, were you and I? Okay, so, and Senator Hartgen, so I think we have 5-4, right? Oh. I'll tell you what, committee, let's do a roll call, then everybody knows for sure what we are. It's okay. No, I haven't voted yet. Aye. Okay. Thank you, everyone. I know these sometimes are difficult decisions. Motion carries 6-3.
Senate will now have before it for final consideration Senate Bill 1087. The Secretary will read the bill.
In the Senate, Senate Bill 1087 by Judiciary and Rules Committee, an act relating to criminal forfeiture, to provide for criminal forfeiture for certain crimes against children and vulnerable adults.
Mr. President.
Senator Okonowitz.
Mr. President, I ask unanimous consent that further reading of Senate Bill 1087 be dispensed with and the journal show that it's been read a third time at length, section by section, and placed before the Senate for final consideration.
You've heard the request. Is there an objection? Hearing none. Senator Okonowitz, you're recognized to begin the debate.
Thank you, Mr. President. Senators, presently, when a person is convicted of a crime against children, such as sexual exploitation, enticement, or lewd conduct over the internet, the items that are used in the commission of those crimes must be returned to that convict once he has completed his sentence. This bill will allow for computers, USB thumb drives, DVDs, and the paraphernalia employed in the commission of those horrible crimes against children to be destroyed. Currently, law enforcement is required to store and then forensically wipe these items of their aberrant content just to return them to the person who committed those crimes in the first place. This new section of code is based on current drug forfeiture laws, but it differs, in one significant way. Drug crimes allow for civil forfeiture. Drug crimes allow for civil forfeiture of items used in the commission of a drug-related crime or that are the fruit of a drug-related crime without a conviction or a trial. In contrast, this bill has no civil forfeiture component, and forfeiture is only employed following a criminal conviction of a crime against a child, which is a much higher bar than civil forfeiture. The bill was brought to us by Detective Neil Uhrig of the Post Falls Police Department. It's been vetted by the AG's office. It has the support of the Fraternal Order of Police, and it's been reviewed by the Idaho Prosecutors Association. And Senators, I'd appreciate your support for this bill. With that, debate's open.
Thank you. Is there further debate? Hearing none. Senator Okonowitz, you're recognized to close the debate.
Thank you, Mr. President. Debate's closed.
The debate being closed, the question before the Senate is, shall Senate Bill 1087 pass the Senate? The Secretary will call the roll.
Adams. Anthony. Berndt. Bjerke. Burtonshaw. Cook. Den Hartog. Dunn.
Aye.
Foreman. Grow. Guthrie. Harris. Hart. Hartgen. Herndon. Just.
Aye.
Lakey. Lee. Lenny. Lent. Nichols. Okonowitz, Robbie, Ricks, Ruchti, Schroeder, Semmelroth, Taylor, Taves, Trakel, Van Orden, Ward King, Winder, Wintrow, Seiderveld, Herndon,
Aye.
Lakey, Lenny, Ricks, Wintrow,
The roll call shows 31 in favor with 2 against and 2 absent, more than enough to pass Senate Bill 1087. This bill has passed the Senate. Is there a correction to title? Hearing none. And the title is approved and the bill will be transmitted to the House. The Senate will now have before it for final.
Next up is going to be Senate Bill 1087. Representative Allgood.
Representative, introduce yourself, and you know the drill.
Chris Allgood, District 11, Madison Caldwell. I am here to introduce Senate Bill 1087, and much like the chair, I will be passing this off to Senator Okonowitz and Detective Neil Urey.
Oh, Senator, good to see you again. Go ahead when you're ready.
Thank you, Mr. Chairman. Doug Okonowitz, I'm the state senator from Legislative District 3. I live in Hayden, Idaho. Today, for your consideration, we've got Senate Bill 1087. So presently, when a person's convicted of a crime against a child, such as sexual exploitation, enticement, or lewd conduct over the internet, the items used in the commission of those crimes have to be returned to the convict once he has served his sentence. So passage of this bill is going to allow for computers, USB drives, DVDs, and paraphernalia, and so on, that's employed in the commission of those terrible crimes against children to be destroyed. Currently, law enforcement is required to store and then forensically wipe items of their aberrant content just to return them to the person who actually committed those crimes with that very same equipment. So this new section of code is based on current drug forfeiture laws, but it differs in one significant way. Drug crimes allow for civil forfeiture of items used in the commission of a drug-related crime, or the fruit of those drug-related crimes, but they do that without a conviction, or they can do that without a conviction or a trial. Civil forfeiture can happen with the preponderance of evidence prior to a conviction. This bill, in contrast, only has a civil forfeiture, a criminal forfeiture component, and it only can be employed following a criminal conviction of a crime against a child. So it's a much higher bar than the civil forfeiture that you see in drug laws. And the bill was brought to us by Detective Neil Urey from the Post Falls Police Department. It's been vetted by the AG's office. It's got the support of the Fraternal Order of Police, and it's been reviewed by the Idaho Prosecutors Association. And with the chairman's permission, I'd like to let the detective tell you about the bill and his work.
All right, we'll open you up for questions after we hear from
Fair enough.
Neil Urey. So if you'll take a seat.
Mm-hmm.
Please introduce yourself, tell us where you're from, who you represent. If anyone, we'll give you a couple minutes, and then there'll likely be some questions.
Thank you, Mr. Chairman. My name's Neil Urey, and I'm from Post Falls, Idaho, and I'm here to talk to you about supporting Senate Bill 1087. I work for the Post Falls Police Department, where I'm a detective sergeant, and I speak to you both on behalf of my police department and also the Fraternal Order of Police. We drafted this bill to resolve a problem that I've encountered in my police duties. Some background, I'm a member of the Internet Crimes Against Children Task Force, as well as a task force officer with the United States Secret Service. As part of my duties, I operate the only full-service digital forensics laboratory in North Idaho. A vast majority of my digital investigations are related to child exploitation and child pornography. Under the current state of the law, when a child pornography offender is prosecuted, the devices they use to commit the crime are taken as evidence, but must be forensically wiped and returned to them at the conclusion of their sentence. Morally, I believe this to be bad public policy. The government should not be in the business of returning tools used by child pornographers that they use to commit these heinous crimes. Bill 1087 provides a mechanism to forfeit these devices, making it so we don't have to give computers back to child molesters. While I use the term child pornography in my testimony, please know that what I really mean is videos and images depicting the violent and degrading rape, molestation, and torture of children of all ages. In my business, we refer to child pornography as child sexual abuse material. Make no mistake, child pornography is the most offensive material in existence, and it steals the innocence for the rest of their lives. A lot of research and consultation has gone into this bill. It's been vetted by the Attorney General's office, prosecutors throughout the state, members of ICAC at the Attorney General's office, and members of the U.S. Attorney's office here in Boise. The language used in this bill has been mirrored from the Controlled Substances Criminal Forfeiture section, and this was done intentionally. The process is something that our courts are already familiar with. This is much different than civil asset forfeiture, which has at times been controversial. In civil forfeiture, property can be taken based on a preponderance of evidence. Bill 1087 uses the criminal forfeiture process. The standard is beyond a reasonable doubt, and the property is forfeited as part of the offender's sentence. If an offender is found not guilty, they get their property back. In my opinion, there's nothing controversial about forfeiting property used by convicted child pornographers and child molesters. Under this bill, digital devices containing child pornography will be destroyed after all court proceedings have concluded. Other property directly involved in the crime can be used by prosecutors and law enforcement for official uses, thereby assisting in future child exploitation investigations. This bill contains language that serves to safeguard the rights of third-party owners. I feel this is important because sometimes offenders own property with their spouse or innocent parties. This language provides them a way to be heard in court and to potentially recover property or the value of the property. Criminal forfeiture of child pornography evidence is well established across the nation. It's used in the federal system as well as many states such as Washington, Oregon, California, Ohio, Nebraska, and Georgia. In summary, 1087 is good public policy that will help law enforcement. The bill is based on solid legal analysis, and it's already used in various states across America. There are few crimes worse than child pornography. Simply put, child pornographers should have to forfeit the tools of their trade upon sentencing. Thank you for your time, and I will remain for questions.
Committee, any questions? Representative Handy.
Yes, Mr. Chairman
Come forward
and
for questions.
absentee.
Don't know who was going to be the focus of the question.
Yeah, it'll be you. So as I was reading the bill, I could see where it was, kind of meshed in with the usual drug trafficking and stuff. But I didn't see that anything ever got excluded. So if you had a child that was molesting children and transporting them, then does that vehicle become suspect and could be forfeited and used by the court for further prosecution of other people?
Answer if you can.
Mr. Chairman, thank you, Representative Handy. Yes, that is potentially the case. If a piece of property has been used to commit the crime and has a nexus to the crime, the judge can make a ruling that way.
Okay.
The reason we have to include all types of property is we don't know exactly what we're going to get into in these cases. I'll tell you one instance I had where I had a child pornographer about 10 years ago. He got out of prison and he used to make his victims dress up in costumes. I had to give him the costumes back.
Oh, dear.
And so we can't just say just the computers, just the USB drives. We have to keep this open because these people use all different things that you won't think about. Yes, there are situations where a car could be seized, but I would think that would be pretty few and far between, but it could happen.
I think it's a great idea. Thank you.
Any other questions of this witness? Representative Nash.
Thank you, Mr. Chairman. I think this bill makes good sense. I don't understand why we would return computer hardware and such that's been used in the commission of a crime. My concern, I have two, is the inclusion of real property. I can't think of a situation where I think it would be appropriate to seize real property based on a criminal conviction. And I do worry, I know there are protections for third parties in here, but generally, in my experience, the victims are related to the individual. So I worry about seizing assets of significant value that might harm potentially victims or spouses and so forth. But I guess what would be the policy justification for seizing real property like a home or land from an individual for a child exploitation conviction?
Go ahead.
Mr. Chairman, thank you. Representative Nash, that's a great question. I've gotten that a lot. The reason we included real property is, again, we don't know the scope of what these cases are going to bring. There have been cases where people have built rooms in their houses for the production of child pornography. That can be a situation where it would be necessary. This would not apply to situations where simply a person is downloading child pornography at their house. That does not provide that nexus. The law specifically states that the judge has to make a determination that the property was directly involved in the criminal act. And if it wasn't, the property's safe. And on top of that, with the procedural safeguard for third parties, there's ways around that. But we needed to keep that in there because literally when we do these investigations, they go in crazy tangents and we don't know where it's going to go. And if it is a situation where we go into a trailer and they're producing child pornography in there and it's set up to do that, I think that it is good public policy for them not to be able to keep the place that they use to produce child pornography.
Follow up?
Yeah, another question, Mr. Chairman. One thing I felt like was lacking in this bill is I don't see any mentions of restitution. It seems like the government would be the ultimate beneficiary of the seized asset. And when we start talking about real property that might have a lot of value, that gives me pause. When we say we're just copying this from the civil asset forfeiture, I'd like more of a focus to be on the victims and making them whole. So I wonder if you could just speak to restitution, and was that something that was considered in the drafting of this bill?
Thank you, Mr. Chairman. Representative Nash, that's a great question as well, and it did come into play in this bill. There is a section that actually talks about it in the bill. And so it's talking about if there's property that was used against the child and it belongs to the child, they get that back. Broader than that, when we talk about restitution, whether that be for counseling or other types of restitution, there are mechanisms in place through our judicial system to cover for that. This just allows for the seizure of property. The prosecutor's office can make a determination how that would be used. My preference is you use it to make the victims whole. That's what the federal system has decided to do with their forfeiture law. And I think that's a great policy. But again, it's based on each individual case. And with all the systems that we currently have in our judicial system, I think that we have the mechanism already to provide restitution.
Representative Scott.
Thank you, Mr. Chairman and sir. I'm curious, and I haven't found it in here, and I'm just wondering if you could tell me. I know for civil asset forfeiture, there's a report that goes to the prosecutor, I think. Is there something in here for what you're disposing of? Is that getting reported somewhere? And if so, where's it at in the bill?
Yes, ma'am. Let me get through this. I know it's a lengthy bill.
Through the chair.
Oh, sorry, Mr. Chairman. I apologize. So if you turn to the very first page, line 36, it's subsection 4, any peace officer of this state seizing property subject to forfeiture under this provision of the section shall cause a written inventory to be made. And then below there, then it talks about how that is implemented. And so we have the prosecutor's office then files a separate allegation And the mechanism is, once a person is either indicted or more likely an information is filed, the prosecutor then files a notice that within 14 days, saying that the items that were seized are up for forfeiture if under conviction. So that's where that's lined out. It's in those sections.
Thank you.
Okay, thank you for your testimony. Is there anyone else in the room who'd like to testify on this bill? Seeing none, Senate Bill 1087 is properly before the committee. What? Another red light? Kenny, Representative Roden.
Mr. Chairman, for motion,
Go ahead.
I move that we send Senate Bill 1087 to the floor with a due pass recommendation.
Any further comment on the motion? Representative Nash.
I am a soft no on this. I think the bill makes a lot of sense. I just have a problem with the real property part of it. If that was struck, I could probably support it, but I just want to go on the record about why I'm opposing, but otherwise, it's a great bill.
Any other comments? Representative Cannon.
Thank you, Mr. Chairman. I'm a soft yes on this for the same reasons that and concerns that Representative Nash voiced. Those piqued my interest, and I will look into those a little more. So I don't want my yes today to be a commitment to vote for it on the floor, but I will be voting yes today on in committee.
Seeing no other red lights, the motion is probably before the committee to send to the floor with a due pass recommendation, Senate Bill 1087. All those in favor, please say so by saying aye. Aye. Any opposed? One nay. Do you want to be recorded? Not being recorded. Motion carries. Thank you very much for your testimony, and Detective for your work.
Thank you.
Hearing none, the title will be approved and the bill will be transmitted to the Senate. House will now have under consideration Senate Bill 1087. Good gentleman from 11.
Thank you, Mr. Speaker. I request unanimous consent to dispense with any further readings of this bill.
Unanimous consent has been requested. Is there objection? Hearing none, the gentleman has the floor.
Thank you, Mr. Speaker. This information was brought to us by a police detective out of Post Falls, and when I looked at it, I wondered why we haven't done this sooner. Our officers from the Idaho ICAC and many detectives around the state investigate child abuse crimes, internet pornography, exploitation of children. The Attorney General estimated that ICAC saw 1,500 cases just in their office last year. It is unfortunately a very rapidly growing crime. Currently, when we prosecute and convict one of these felons, after their sentence is complete, they have a right to have all of their equipment back, their computers, their storage media, all the rest of that stuff. It is required that law enforcement wipe the computer clean and return it to them, whatever material that may be. Like I said, these items commonly include their computer, media laptop, any other implements they may use, and it can extend to much bigger things, but those are the most common things. What this bill does is it creates a forfeiture process, so after a person is convicted of one of these crimes, the prosecutor can file an additional charge to have them forfeit anything they used in the committing of this crime and any proceeds they derived from the committing of this crime. And it's not a civil forfeiture such as a drug case. This is a criminal forfeiture that goes along with the sentencing. So it only happens if the person is convicted, and this follows. Anyway, I think that you got the gist of it. I'll stand for questions. Thank you.
Thank you, good gentleman. You've heard the motion. Is further debate on the motion? Hearing none. Debate is closed. Question is, shall Senate Bill 1087 pass the House? Clerk will unlock machine and the members cast their votes. Everyone voted. Does anyone wish to change their vote? Clerk will lock the machine and record the roll. 67 ayes, 3 absent and excused, majority having voted in favor of Senate Bill 1087. Senate Bill 1087 is passed the House for correction title.
No correction to title.
Now the title is approved, bill be transferred to Senate. Good lady.